others to it, or if you need to see it. Otherwise, welcome to our Zoom friends that have joined us as well. And grateful for what's become an annual report on the state of the SCOTUS, Supreme Court of the United States, and particularly oriented around religious freedom. Just a couple of words about TEI. Thank you for your ongoing prayers and support. And just got our end of the year fiscal numbers, and we have exceeded budget once again this year by a tad. And that gives me faith and confidence sufficient to continue to do what we do again for next year. So we rejoice in that, and are grateful to the Lord's provision for us to continue to provide the resources that we do. And so that's a celebration. And yeah, so keep up the good work. If everybody does what they're doing, then we can continue to do what we do. Also, a word just about our YouTube channel that I mentioned, Theological Education Initiative. So a variety of resources there. So you might go in and kind of check some stuff out, and it becomes a wonderful resource for whatever you missed, as well as for whatever others may be helpful. So there's some really great content, particularly this last year. Kirk McGregor on the book of on church history was pretty powerful. So if you missed that, it's a long thing. Speaking of Kirk, he's going to be with us again in December, mid-December, and sort of a Monday, Tuesday-ish type thing. And he has written a book on Molinism, of course, that we've had him talking about, Luis de Molina. And he is just completing another book on Molinist ventures, Kenny. So meaning how Molinism influences a variety of ethical and theological and philosophical realities. And so he's sort of applying it to a variety of topics, including ones he doesn't even agree with, but saying, if you find Molinism some benefit to it, then here's how it specifically applies to your situation. So he'll be with us for that. Looking forward to that. And then I've asked Jim Wilder, if any of you followed us in his lunch lecture related to neurotheology, the study of the brain, a friend of Jane and Dallas Willard's, that ministry. Anyway, Jim Wilder in the spring, hopefully, to come and talk to us about this kind of how neuroscience informs what we know about how people change and spiritual formation. Looking forward to that. And then also in conversation with our friend Michael McClymont, who's just finished a book on monks, mysticism, and martyrs, Christian formation through the centuries. So talking to him about hooking up with us. So some things in lunch lectures in the fall, etc. But enough of that, we'll get right to it. So this is our good friend who I met when I was still a maintenance man at McDonald's. He used to come and sit and study and work, and along the way we met at the Christian Legal Society on campus. Jason Klum introduced us back in the day, one of his students, an attorney still. And Carl has been active in a variety of sort of under the surface issues related to local religious freedom. So I won't go into all those, but anyway, we worked together in a variety of things that needed to be done and some that still need to be done related to equal access and campus ministry work, etc. But he has also had national influence related to the protection and oversight of our religious freedom. He's an author of a book that's over on the resource center there that we appreciate, and just a great help to keep us. I think of him as a treasure. So anyway, please give a warm welcome again to Carl Esbeck.
Let's go. Thanks, Rod. And so I'm going to talk for 60 minutes, and then we'll have Q&A for 15. That's what we're hoping for. And that's going to be frustrating for you who have a profession of talking. So, so I can't help you with that frustration. But do jot a note to yourself in the margin of the handout or whatever paper is at hand, so you don't forget that question that occurs to you when we finally get around to that. So you should have the handout if you're on the Zoom at home. I think that's available by clicking what, Rod? Or-
Oh, the chat. Yeah, down at the chat, just hit the link. Thank you for reminding me about that. So the file is in the chat. If you'll click on that, you'll be able to access that Google Drive link.
All right, and so there are 4 cases listed there, numbered 1 through 4. And those are the 4 religious liberty cases that were decided during the last Supreme Court term. The Supreme Court term begins the first Monday in October. That follows an English tradition. And that's when the Supreme Judicial Courts open their term in London. And so we follow that tradition, as we do follow a lot of English juridical traditions. And the term technically ends in September, but for all practical purposes, it ends at the end of June. And of course, by and large, there is truth to the teaching that the hardest cases come down in June. So we have 4 cases, and then there is a 5th case, which is unnumbered. It's a case that's coming up next term. So that will be October 2022. That's how we number the term, even though that 2022 October term will, of course, spill over into the next year. All right, so those are the 5 cases that we're going to talk about. The 4 cases that were decided, they're listed here, and I'm going to talk about them in the order in which they're listed. It's the order not of importance, but the order in which they were decided. In fact, the first case, I think, is probably the least impactful of the case of the 4. So that's the order that we're going to take them up. So keep that in mind. Just some preliminary remarks. So as you know already, there were 4 religious liberty cases last term. Religious liberty won all 4. All right, well, that's pretty impressive. And if you go to the prior term, which would be dubbed October 2020, there were 3 religious liberty cases. Religious liberty won all 3. And if you go to the term before that, which would be called the October 2019 term, there were 2 cases and religious liberty won them both. So that's really impressive. So it is true that the state, at least on the books, the state of religious liberty law has never been stronger in the history of the United States. But on the other hand, there has never been more cultural challenges to religious liberty in the history of the United States. Now, to be sure, we've never been bigger, we've never had more population, we've never been more litigious. So just by sheer size and population and the litigious nature of Americans, we solve problems in the courts often rather than other ways, as do other nations. But still, there are challenges over and over and over again. And of course, challenges to religious liberty are by government. When we talk about religious liberty, it's over against the government. So in many instances, and as we get into these cases, these 4 cases that were decided are, some of them are exemplary. It's where local government officials ignore the law, violate people's rights, make them sue them, and you have to, in order to get relief, go all the way, in this case, to the US Supreme Court to get relief. And it's not just government officials, but it's the lower court judges who are refusing to follow the law. one of the preliminary things I want you to hear is these 4 cases, by and large, don't make new law. They just reaffirm rules that I would have taught to my students. These are the rules, boom, boom, boom. Like it or not, here's the cases. These are the rules. And these 4 cases don't change, they just apply the rules. So they're cases where the lower courts have gotten it wrong. And lower officials, before the lower court judges got it wrong, lower officials got it wrong, violated people's rights. The lower courts didn't get it right. And finally, you have to get it right at the highest Supreme Court level. And the Supreme Court only decides 60 to 65 cases a year. And they get requests for 5,000 a year.
Wow.
So there's a lot of cases wrongly decided, some of which are religious liberty cases. They just can't fix it all. They can't even fix a small percent of it. Right? So that's kind of the good, the bad, you know, the black, the white here. There's a continuation of a bad trend. It used to be that religious liberty was not partisan, wasn't Democrat, Republican. But we saw coming 15 years ago, you know, it's recorded in the literature, well, religious liberty is kind of sorting itself out, not by liberal, conservative, or other philosophical or jurisprudential indica, but by party. You know, and our parties are both big tent parties. So lots of ideologies under each tent. But nonetheless, increasingly, it was, and the cases now are just a continuation where religious liberty, this is bad. This is bad for religion. It's bad for Christianity. That religious liberty is a bastion of the Republican Party, not all of it, to be sure. There are Republicans who could care less about religious liberty. But, and the forces contrary to religious liberty are Democratic Party forces. That's bad. And we just see it having gotten worse. And we saw it coming. And then everybody saw it coming 5 years ago, and it was getting, and I don't know how to get out of it. I know how we got into it. I don't know how we get out of it. And it's bad. Bad for religious liberty, bad for Christianity. Just as an example, I mean, Bill Clinton was good on religious liberty. Bill Clinton signed the Religious Freedom Restoration Act, 1993. Bill Clinton signed the Religious Land Use and Institutionalized Persons Act in September of 2000. Both of those highly protective of religious liberty. His party, in their platform, has taken positions against both acts, signed by a Democratic president not so long ago. So I use that just as an illustration of how quickly things have moved. There is an emergence, that's not complete yet, of a constitutional interpretive theory called originalism. It's a conservative jurisprudential theory, part of the conservative liberal movement, and it emerged pretty strongly in some of these cases and other cases that we won't talk about, like Second Amendment stuff. Originalism, which is basically that the Constitution or a statute adopted by Congress, it should be interpreted by the courts in accordance with its original meaning by the author. So if it's a statute, the author is Congress. If it's the Constitution, of course, it was the Philadelphia Constitutional Convention of 1787, and then ratified by the several states and made operative in 1789 and so on. Or if you're talking about the Bill of Rights, of course, the Bill of Rights was adopted 2 years later in 1789 and then ratified by 1791. So you go back and you look at what those gentlemen, yes, all white, property gentlemen, and what they said they thought they were doing, which is a historical task. And it's, you know, the task of getting history right is a difficult one, and reasonable people who aren't ideologically driven can have different views and takes on what the historical meaning was. But anyway, that's how it's to be interpreted, as opposed to alternative interpretive methods, which are being rejected in these cases. And another theme that I'll say a little bit more about is the court is wanting to follow rules, not standards. Rules, black and white. You can do this, you can't do that. Okay? If you do that, that's unconstitutional. But if you do this, that's okay. It's not unconstitutional. Rest rules. Standards are, well, you're going to look at these factors and you're going to weigh this factor against that factor. And here's a factor over here that might enter in. And here's another factor that might enter in some cases. And if it enters in, you kind of put that into the mix and you weigh this and you weigh that. And then you exercise reasoned judgment and figure out who the winner of the day is. Okay, that's a standard. So they're moving towards rules, not standards, because rules tie the hand of judges. Either the judge, the lower court judge, followed the rule, or she didn't. If they didn't follow the rule, get reversed. None of this, well, you know, on the left hand this and on the right hand, okay. None of that stuff. Tie the hand of the judge. Follow the rule. All right, this sounds a little bit like parenting. Okay, you can go with that. One last sort of general comment, it will come as no surprise, but it needs to be articulated nonetheless. The biggest challenge to religious liberty is LGBTQ equality. And that's been true for really since 2000. Okay, so that's been true for 20 years, but it's increased. All right, first case then, Ramirez versus Collier. This is a case that held, well, an inmate who's being executed sought to have his pastor, in this case a Baptist pastor, in the death chamber, and that was allowed. But what was not allowed was that the pastor lay his hands on the inmate and pray audibly. Neither one of those two was allowed. The Supreme Court said, no, that violates the law. That violates the inmate's rights. In this case, statutory religious liberty rights. Under a case, which I mentioned a little bit ago, it's kind of a mouthful, the Religious Land Use and Institutionalized Persons Act of 2000. Which says, with minor exceptions, prisoners have religious liberty rights, and religious bodies, including churches, but other religious organizations like TEI, has rights in zoning, because zoning officials would often discriminate against churches and other religious bodies. And so these two kind of funny cousins, if you will, and there's quite a long statutory history. I was in Washington and on the inside with this legislation, so that would be another seminar. But anyway, that's how it works. So here you have an inmate, and they're in the hands of state officials. So Congress is using the Commerce Clause power, to regulate the religious liberty of state inmates, in this case, when they're being executed. And there's a little bit, I won't go into it at length, but there's a little bit of a history here. Back in 2019, there was a case in Texas, and they're executing an inmate, and the inmate was a Muslim. No, I think it was a Buddhist. No, it was a Muslim. And Texas at the time had a rule that a chaplain of the prison system could be in the execution chamber with the inmate. But this being America, where Christianity and to some extent Judaism are the most common religions represented, understandably, the chaplains on staff, on the payroll in Texas, there was a Protestant and a Catholic, and they had on contract a rabbi, and that was it. So the guy had three choices, and none were an imam. So he takes it, and the Supreme Court, in a 5-4 decision, and these things are done literally at midnight, because 1 minute past midnight, they execute. He was, the lower court had stayed and said, oh, this violates religious liberty. The Supreme Court, by 5-4, reversed, and the guy was executed. Well, there was a huge, once this came to light, because most of us sort of ignore this capital punishment stuff. And there are faithful religious people who oppose this and will show up at the, outside the gate of the penitentiary where the execution takes place. And they're quite faithful and sincere in their beliefs in that regard. And there's certainly biblical warrants for that position. But for most of us, this kind of literally happened in the midnight while nobody else was watching. There was this huge outcry by mostly Christians. This is wrong. And so it took a while, but there was another case came up 2 months later, and it came out with a different result. And this one was a Buddhist, same kind of situation. And the courts stayed the execution and said that the state either would produce a religious leader for the Buddhists, or Kavanaugh, in a concurring opinion, said, well, the rule here is one of equality. So the state could just have no clerics. Nobody is in the execution chamber except the execution staff. Somebody to put the intravenous needle in, and somebody else to start the drugs, and that's it. But no cleric. And then another case came up, and so the lower court, the lower correction officials had said, okay, nobody in there, no clerics in there. And the Supreme Court again said that violates the First Amendment, because the rule, contrary to what Kavanaugh had said, the rule is not equality. The rule is a religious right outright, because that's how our LUPA reads. Our LUPA is not an equality statute, it's a positive right. And so the court, over a dissent by Kavanaugh, followed the statute. Statute gives it a right, not absolute, but a pretty strong right to not be dealt with in this way. And unless the state can show a compelling reason to exclude the cleric of choice can be in the room. And then, but that was to be in the room and silent and not touching. And then the case decided this term was touching and prayer. All of which is maybe too long on maybe the least important case of these four, but it does make a strong statement and puts the lie to the not infrequent lie that the court is interpreting the First Amendment to favor Christians and nobody else. That's an absolute lie. And this case is a testimony to that, because none of these inmates were Christians, and they won nonetheless. Pretty strong statement of religious liberty for people who are just going to live literally a few more seconds, nonetheless.
Mhm.
All right, second question, Shirtley versus Boston. This is what we call a free speech equal access case. And when the character or nature of the speech is religious. So it's a free speech case. So but it's a win for religious liberty because the speech is of religious content. And this has been the law of the land since 1981, a case called Whitmar versus Vincent, which has somewhat local color. Whitmar versus Vincent was a successful lawsuit by students against University of Missouri at Kansas City. UMKC said, we as a university, we recognize all kinds of student affiliated organizations, but if they're a religious student affiliated organization, well, we'll recognize them, but they can't meet on campus. In other words, they're second class citizens, and that goes to the Supreme Court. And by 8-1, the Supreme Court said, no, that's a discrimination against the content or because of the content, which was religious content. And that violates the free speech clause. And so the University of Missouri, one of the four campuses, got a pretty bad slap down. So this is old law. The facts here, why did this case ever have to be taken to the US Supreme Court? And it's because lower court officials and then lower courts got it wrong. How in the world could you misunderstand law that is 40 years old? 40 years old. This is a simple case. So the city of Boston creates a limited public forum, and it's a kind of an unusual public forum. They had, as many municipalities do, they have a flagpole outside the municipal building. This one had 3 flagpoles, and one they would always put up the US flag, and one they would put up the flag of the Commonwealth of Massachusetts. And then on the 3rd flagpole, and they would always keep these, they wouldn't alternate, confuse people. They would always be pre-assigned poles, right? So only one of the poles became a limited public forum. Normally, on the 3rd pole, they would put up the flag of the city. But from time to time and upon request, if a group was visiting the Boston Common and they were going to have a speaker in the Common, literally sometimes put up a soapbox and stand up on the box and speak, if they requested enough, a couple days in advance, they could put up the flag of the organization on this 3rd pole. So they would take down the city flag and put up the flag of the organization for 1 hour when the speaker was speaking on the Commons. And there was a history of 4 or 5 years of doing this. And they had 250 more or less requests to put up their flag when their speaker was speaking. and they never refused a single request, not once. Until a conservative Christian group asked, called, and I don't know what this group does, I'm kind of inferring, it's called Camp Constitution. And I don't know what they do, and I probably should have looked at their website to know. I'm inferring from their name that they put on workshops for people who want to study the Constitution from a quote unquote Christian perspective. But maybe that's not what they do. In any case, they're a Christian organization that wasn't disputed, and their flag was the Christian flag, which you occasionally see. You occasionally even seeing if you're in a liberal Protestant church, they'll even have the Christian flag at the front of the church along with the U.S. flag. You don't usually see that in conservative Protestant churches, but sometimes you do even there. And
You are correct in their mission statement. That is what they do.
okay, good, thank you. So so you know, it's a white flag with a blue field and a red cross. So you know, obviously Christian, and with their request, which went to a bureaucrat who turned it down, and he said why he turned it down. He said it was Christian. Well, we can't have Christian on the flagpole. And of course, that is a flat out denial because of the content of the speech, because it's religious. It happened to be Christian in its religious character. But there was no indication that if it had been Jewish or Buddhist, that would have been okay. In which case, it would have been discrimination on the basis of viewpoint as opposed to religious content. Well, so city authorities defended this. The lower courts, amazingly, where did they go to school? Harvard, nearby across the Charles River, and lower courts affirmed this, but obviously it's unconstitutional. Now, so it's a unanimous decision, and it's interestingly enough, it's written by Justice Breyer, who of course just retired, one of the three liberals. It's crude, but I use it too. You know, the court is roughly 6 conservatives and 3 liberals. And of course, with the addition of Jackson and the subtraction of Breyer, that calculus of 63 doesn't change. As long as you understand that's just a crude rule of thumb, I think it's accurate for us to use it. So, so Breyer writes the majority opinion, and it's he draws 6 votes, his own and 5 others. And he sets up a standard. And I give you there, well, there's this factor. And of course, the test is this private speech? Because at this level, the city of Boston defends himself because they're saying this is government speech. Whatever flag goes up is government speech. Even though some of these 250 flags that have previously been allowed to fly, they were flags of various countries, flags of various foreign organizations. Palestinians could fly. State of Israel could fly. You know, different messages there. Note that. But they said, well, this is government speech. And of course, if it's government speech, it's unprotected by the First Amendment, because the First Amendment is there not to protect government from government, but it's there to protect us from government, private speakers, right? The whole Bill of Rights is to protect us from government. And so if it's government speech, and sometimes the government does speak, like you might see a sign that says, don't be a litter bug. Well, that's the city of Columbia speaking, that's a government. So that's unprotected speech, okay? But so if it's government speech, then there's no freedom of speech. But you know, it's pretty clearly these flags were private speech, and even under the multi-factor test and weighing this against that and so on, even Justice Breyer got that right, that this was private speech. Whereas three conservatives led by Alito would lay down a bright line rule. Okay, again, there's this distrust. It's interesting. Conservatives, they're not anti-government, that's libertarians, but conservatives distrust government. It's a healthy distrust, but it's not anti-government. Well, so here's Alito saying we have a healthy distrust of our fellow colleagues in the lower judiciary. So we're setting rules. Now here, of course, the rule didn't prevail. We're stuck with, at least for a while, standards, loosey-goosey standards, trying to sort out, is this private speech or government speech? All right, let me let go of that one. Number 3, Carson versus Macon. It's close, but I would say this is the most important of the 4. Because it's a school choice case, and not just ability for the parents to choose, notwithstanding government regulation, but it's money follows the choice, and money talks. A lot of times you can have a right in the abstract, but you can't use it because you're poor or you're middle class. A lot of middle class parents can't afford, even though they think it would be best for their child and his or her situation, they can't choose private school. So, so you have a right, but you can't realize it because you don't have the money to realize it. So the fact that something is funded is a substantive difference. So Carson versus Macon is the third of a line of 3 cases, which says that the free exercise clause, the government can have policies to fund or not fund activities in the private sector through grants or other transfer payments or through vouchers or through tax breaks, tax deductions, tax credits, all kinds of ways of funding activities in the private sector. But if they fund, here comes the free exercise bite. If they fund the private sector, they can't discriminate against religion. So here, the state of Maine has a public school system, as does all other 49 states. But there, of course, also are private schools in the state of Maine. I didn't realize this, my guess would have been Wyoming, but apparently Maine is the most rural state of the 50 states. And so there are large tracts of, I suppose, Northwest Maine, which has no public high school. The state is able to sustain a public elementary school, but not a secondary school or high school. So if you have a child of high school age and you live in one of those remote areas, the state didn't just say, well, you're on your own. Too bad you chose a bad place to live. They gave an option. They said, I know it's going to be a long ways away, maybe 40, 50, even 80 miles, But if you can get your child to the nearest public high school, you can enroll them there and the state will pay for it. Pay for it. So, you know, I suppose you could have a child who's in a boarding situation 50 miles away, and your child comes home on weekends or something like that. Or the state said, you can take your child to a private school and we will pay an amount, the same amount that it costs on average for us to educate your child in a public high school. We'll take that amount, you know, 12,000, 15,000, thereabouts per year, and we'll give that amount to the private school that you chose. Unless you choose a sectarian high school, then no pay. Okay, classically wrong, unconstitutional. State and the lower courts affirm this. And they come up with some distinction, which quite frankly, the Supreme Court ridicules. They were none too kind to the Federal Circuit Court of Appeals. And I think deservedly so. And on that 3-judge panel was a former US Supreme Court Justice, Souter. Isn't that interesting? Mm. And he wrote the opinion, which was reversed. 6-3. Isn't that interesting? Of course, he was very liberal on church-state matters back when he was on the Supreme Court. So, so the beginning of this line of 3 cases now was here in Missouri. In fact, it was here in Columbia. It's the Trinity Lutheran Church case. Isn't that lovely? I've gone over to the playground and snapped a few pictures to send it to some of my friends on the East and West Coast. You know, they want to see the playground. And then there was a case out of Montana decided just 2 years ago called Espinoza, a tax break case, tax deduction case, same sort of deal. Now, don't misunderstand the holding here. The state of Missouri is not bound when it comes to its primary and secondary education by this case for reasons of, and I'm using Missouri here just as an example. But since we're sitting here in Missouri, it sort of comes to roost. Missouri, black letter, and then I'm going to drop a footnote. Black letter, Missouri only funds public schools. So Missouri didn't do what the state of Maine did. Missouri didn't do what the state of Montana did, okay? They, again, what Maine said is we're not just going to fund public schools. We're also going to fund private schools, but then discriminate against the private religious, okay? So Missouri's okay because they only fund public schools, okay? I say this because critics on the left are distorting this. And they're saying, oh, now a state has to send the same amount of money to private religious schools. That's not true. Okay, it's only if you fund also, in addition, private schools, do you have to treat the private religious the same as the private non-sectarian. All right, now the footnote is important. Actually, Missouri does fund private primary and secondary schools, which is unthinkable when I moved here back in 1981. Because when I moved here, and I was I'm not a Missourian and unfamiliar with Missouri, even though I grew up not so far away, but still completely naive about Missouri. And I grew up in Western Iowa. Other than that you sold fireworks in Iowa, that was about the extent of my knowledge of Missouri. I'm sorry. But Missouri back in 81, there was this Catholic Baptist thing. And the Baptists were dominant in this issue of school funding. So Missouri, unlike almost every state in the union, they wouldn't even fund busing for kids to go to Catholic school. So now a couple years ago, because I see some of you frowning out there, that can't be. It is. A couple years ago, our General Assembly passed a bill, and the governor signed it, that alters the Missouri income tax code. And it alters it in a way in which 7 or 8 states had first altered it. So Missouri wasn't a leader here. 6 or 7 other states were ahead of Missouri. I think Arizona was first. And they changed the code. So they said to the Missouri income taxpayer, so you have to pay a Missouri income tax. But if you pay a Missouri income tax, you can give money to a private corporation which is set up as a student scholarship corporation. That's all they do. They give student scholarships to kids enrolled in elementary or secondary schools in the state. And then that scholarship awarding corporation awards scholarships to those kids, and they have to apply. And of course, part of applying is that if I don't get this scholarship, I'm going to have a tuition bill at my private school, because public schools don't issue tuition bills. Unless, of course, you're attending a public school district that's not your public school district, in which case you do have a tuition bill. All right. So if I give money to this corporation, then I get a Missouri tax deduction. So my taxes are reduced. That's state funded. And then the private scholarship fund funds these students to attend, almost all of them attend private schools. Although they could attend a public school. But like if a kid in Boonville wanted to attend the Columbia Public Schools, if you could get admitted, that would be discretionary with our district, but if you could get admitted, you're going to be sent a tuition bill. And so you could ask for a scholarship to defray the cost of that tuition bill too. So Missouri, I don't think this is well known, actually funds private religious schools, including private Catholic schools. Oh, all right. And I assume this bill never would have passed, but at least some Baptists were in favor of it. So that's kind of interesting. So school funding, school choice, quite a revolutionary change. When I was in law school, there was a phrase used by Americans Separated for Church and State, say no parochial aid. The rule from the Supreme Court down was no parochial aid. And that has been completely stood on its head. I mentioned this, there's kind of side issues here, not in this case, but there's been quite a reaction yet to see how it all shakes out, where parents of public school education students have become quite discontent with their public school education. By and large, before the pandemic, public school parents were okay with public school education. And that has really changed, partly due to the pandemic, because school boards, and this is a broad brush, school boards turned a deaf ear to what parents wanted when it came to how the pandemic was treated. And all of a sudden, their 3 kids were trying to work with computers out of their kitchen table when they because they held two jobs, both mother and father held two, each held a job. They wanted their kids at school live, not home at the kitchen table trying to learn. But then parents also learned what some of those students were being taught. So, it was critical race theory. It was 1619 project run by or advocated by the New York Times. It was getting the right pronouns, and human sexuality. And then this was kind of building on, having nothing to do with the pandemic, but how do we treat transgenderism and the locker rooms and the bathrooms, and what are kids taught concerning sexuality, human sexuality, when they're first graders, second graders, and third graders, and so on. There I'm referring to the Florida law, for example, which was misnamed Don't Say Gay law, and so on. So it's, and all that school choice feeds in a major way into that kind of an issue, because if the parents are discontent with the public schools, then they're looking for an ability to exit, but many are simply middle class. And the idea of paying, I don't know what, say, Tolton High School is here in town, but I'm thinking it's probably $12,000 a year per student. And the idea of paying that for 2 or 3 children is simply not even close to being within means of a middle class Missourian, even if both mother and father, are pulling down paychecks. So just kind of watch that whole, it's just a very interesting tie-in. And it kind of ties into what I mentioned earlier, the LGBT issue. Because the teachers' unions are strictly public school teachers' unions, and they have a lot of control. Some would say too much control. So there's this very, very difficult question for the church. By and large, the Protestant church, with the exception of Missouri Synod Lutheran, have been public school supporters. And there's an open question as to whether the public schools are becoming too philosophically hostile. And the public school in Houston, Missouri, which is a pretty rural county, probably 3,000 people in the whole county, as opposed to a public school, say Columbia Public Schools. Those are 2 different kinds of public schools altogether. So the parental experience is very different. I certainly have friends who say they moved to Ashland. Why? Well, it's to escape the Columbia Public Schools in the negative, but it was also to take part in the Ashland Public Schools, which I don't know what that's called, Southern Boone County Public School or something like that, which I don't know anything about, but at least my friends say that they're quite pleased. So there's public schools and there's public schools. It's a hard question for the church, because we want to be salt and light in our culture. And yet, we don't want to use our children, right, to crack open otherwise hostile cultures. One thing to subject ourselves to hostile environments, another thing to subject our 5-year-old. Yeah. All right, last thing is the Kennedy case. I thought this had, I put this in second place in terms of most impactful, not first place. And but it does, it has an impact on optics. And so some would say it was the most important religious liberty case of the term. in one sense, it's a nothing case. There's a certain element of the American male that when you put football together with public school prayer, they just go crazy. In fact, they put football together with anything and they go crazy. And football and prayer, they can just go wacko. And suddenly this Coach Kennedy is the greatest hero of, I don't know, he's another Jonathan Edward or something. And this guy has a very checkered past. Okay, that's just a fact.
Oh, boy.
Now, we're all sinners, but for the grace of God, we'd fall short. But he is not something that you would want to hold up as an example of a fine Christian citizen and gentleman. But it's impactful in the sense that there's this myth that ever since early 1960s, when the school prayer cases came down, 1962, 1963, I know while I was alive, most of you weren't born yet, but when those cases came down, and politicians demagogued those cases. But a myth was created that, and I'm a public school product, public school education product. My mother was a public school teacher. My sister was a public school teacher. So I kind of lived this myth that the public schools were secular. Secular in a good sense, and they were common, where common people of diverse backgrounds, including diverse religions, could come together, and everybody tolerated everybody else, and everybody was neutral, and so on and so on. And you were going to be taught neutral things. I blame the state colleges of education for this. The notion of secular neutrality was distorted and exaggerated, and neutral became the complete absence of religion. And the prayer cases never required that, never. The prayer cases, like Schimpf, 1963, said, of course history should be taught, including the religion's contribution to history. Of course, public school children should study the Reformation, of course. And, both sides of that, and the impact of, the European religious wars and the English Civil War, which was very much a religious war, not entirely, of course. All of that should be taught. That's what the Supreme Court said, but that's not what happened. It became a total absence of religion. So let me give you just a real true example, my personal experience. So the University College of Education was running a lab school of kindergarten age children. And so they had 30 students, and they were using this to train College of Education students. And the assignment was for kindergartners was to draw a picture of a winter scene. So all the kids drew a picture of the winter scene, and they were all put up, nobody excluded, no matter how good the art was, except one little girl's art, where she drew the manger of Christmas. And the teacher, oh no, we can't put that up. That's religious. And she was kind of a little brokenhearted about it, but you know, teacher says, so she accepted that. But one of the students was also a Cru student, or back then Crusade student. And she didn't think that was right. She went and told her campus rep, and the campus rep called me. Of course, I knew that was wrong. And that's the student's speech. This is a limited public forum. And this little girl's being ruthlessly having her speech discriminated against. So I called university council, and the university council called the dean of education. The dean of education called the teacher and leading this and said, you can't do that. Of course, by then the art had been destroyed and the students had moved on. You know, all this takes 3 or 4 weeks. That's secularism, ruthless. The Supreme Court never required that. And this result here rolls back on that. Okay. So in that sense, it's kind of interestingly impactful. It simply affirms what the law used to be. And there were all kinds of people running around saying, not that the sky is falling, but the Jeffersonian wall is falling, right? As if this was terrible. Well, it's just affirming what the law has always been, but they didn't know it. These were adults who should have known better. And they had this mythical notion, which they had probably picked up, like I had, going through public schools, that this is a complete secular wasteland. But Coach Kennedy wins the day, such as it is. All right, well, I don't want to talk about, because Q&A time is up, I don't want to talk about the cases coming up, but it is LGBTQ versus religious liberty. And it's what I call a wedding vendor case, and there have been several of these. Florists, Christian bakers, including the baking of wedding cakes, and a Christian wedding photographer of New Mexico, and so on. Some of these cases are decided one way, sometimes the other way. And in this particular, I didn't even know that such a thing existed, but they're wedding website builders. And if you get engaged, you announce your engagement on the website. And then, of course, you set your wedding date. And so you begin to prepare your audience. I can't imagine if there being an audience for this, except the parents of the couple who are engaged. But so anyway, I guess these websites have become important. And so they pay money, I don't know what it is, $300 for some help, being helped to build a website for your impending wedding. And as a Christian, she wanted to announce, so that she didn't get unwanted clients. She wanted to announce in advance on her website that she was a Christian and therefore could not take a client for a same-sex marriage. That would violate Colorado law in a case. She lost below. And here, I don't blame the lower courts for ruling against her. I'm sorry they ruled against her. I think she should win. I do think she'll win in the Supreme Court. But this is an area of the law which is unsettled. So, you know, a lower court judge could, with complete sincerity, go either way. And here's the big issue is discrimination against the LGBTQ the same thing as racial discrimination? If so, you'd have to rule for equality and the LGBT. They say it's the same thing, liberals. Conservatives say, no, it's not the same thing. You know, racism is altogether different. We fought a civil war. We passed the 13th, 14th, 15th Amendments, et cetera, and so on. It's completely history of slavery and so on. So it's not the same thing, which is not to deny that there hasn't been discrimination against the LGBTQ. Obviously there has. And so therefore, which is the greater value? Religious liberty would be the greater value. If you don't see LGBT discrimination the same as racial discrimination. So I say I think religious liberty will win, but I'm not altogether sure.
All right, thank you, Carl. Yeah, let me get the party started if I could with just first of all a comment and then a question about vocabulary. So I was struck and just comment by you're saying that in so many respects in your qualifications before you started is that education is the problem. This issue of thinking about the myths that are created, that how the lower courts are thinking apart from the rule of law and those kinds of things you see as such a great threat. And that's very curious to me. Apart from the judicial piece, it's just the mindset of secularism, et cetera, et cetera. So I found that very, very interesting.
Yes, I would distinguish between the general culture and their miseducation, which is what you're reading back to me.
Yeah.
And I think that's a big problem. But judges and government officials who, if they're not sure what the law is, can go check with their lawyer, right? Governments have lawyers. I don't excuse the lawyers giving bad advice. I don't excuse the judges getting it wrong. They shouldn't be affected by culture. In fact, by profession, they're supposed to be walled off by culture. They're not to have cultural biases. That's what being a judge is about. Or being a corporate lawyer who is assigned to keep your client out of the losing side of a lawsuit. And so they should know the law, and the law is there to look up.
So therefore, what is their quote unquote explanation or motivation? Is it, would you say a major variable is just they didn't take your class? Not to be simple, they're not understanding. You made a passing reference to Harvard. Were you being sincere, joking, or is it too complicated to really say? But the lower courts are making bad decisions that the higher court, the Supreme Court, is correcting currently.
Yeah. Well, you're right to press me on this. And it was a joke that Harvard was simply miseducating Harvard students. And who knows what corporate lawyer gave the city of Boston bad advice. But it is embarrassing to lose 9-0. And to lose even the liberal votes, right? But I think it's, it is complex. When I say I don't excuse the lawyers for giving their client bad advice and the judges for getting it wrong, I think it's their legal philosophy.
Mm-hmm.
Are they of conservative legal philosophy? So their job is not to decide the case based upon what they think is right. Instead, their job is to decide the case based upon what is the law. That's a conservative judge.
And I can get there by a
now, if liberal, half the judiciary are liberal judges. That's not their philosophy. Their philosophy is, well, there's this and there's that, and what do I think is right here? What do I think is just? And then their personal values get interjected wrongly.
Right. So therefore, so that goes to my question then. So originalism, which you find is a positive word.
Yes.
And precedence, which is also how they ought to follow the rules instead of the standards. When in that 8-1 decision of UMKC, that one individual, I'm curious for you to just give some naming of that one. What is it that they could do that the other 8 didn't do? And my assumption is it's going to be something along the means of evolutionary or philosophically but I want to use a different term other than liberal. I want you to use a term other than that. Give me what the word is. They are deciding a better society based upon their own assumptions and presumptions about how the world works. What is a word for that other than, if there is one?
Yeah, well, so what's a competitor to originalism? Well, sometimes called the living constitution. In fact, that's the most common label.
Mhm.
Now, some liberals don't like that because it's easy to ridicule, right? A document doesn't live. But if you listen to what they're what they're talking about, they're just saying that we as judges are specially positioned. We're isolated from politics. Through training, we're able to look at all of the competing ideologies. We're able to look at the American culture. We're able to self-assess. And we don't do this alone because judges, by and large, don't act alone. They act in groups. So there is some sharing of the authorities. Nonetheless, we're still a fairly small unelected group, right? We're able to kind of foresee the way an enlightened American republic would go as things change, and we don't want to move too fast. We don't want to get way out ahead of the culture, but we don't want to move so slow that things sort of stagnate in the past.
Yeah.
And so, and I think that's a complex way of saying it's personal preference lawmaking, but it's a small collective of personal preference lawmaking.
And this tension existed within your tenure at the law school here, correct? As it does in most all law schools, other than a Christian university. Is that accurate to say that that tension existed among some of your own peers?
Well, sure. Originalism is taught, as is a living constitution theory.
Okay, so it all exists within the,
Yeah.
All right, now, did the originalists, and this is my last, is this statement accurate? That the originalists, that the founders of the Constitution, et cetera, originalism, they intended a pluralist society as opposed to a secular society? Or would you rather say they intended free exercise within a pluralist society, but not secularism, exclamation point? Am I picking up what you're laying down in crude ways?
Yeah, well, because they wouldn't have used the word pluralist. You know, that's kind of our term for it.
Okay.
They would have said, we start with a tolerance, including religious tolerance, but also political tolerance. And it's not just tolerance in the sense of the state begrudgingly allowing you to be different while holding the power to snap you in line if you get too far afield. In other words, it's not a tolerance like the Church of England operated on the American colonies. You know, there were certain religions tolerated, others were not, like Catholics were not tolerated. But even the ones that were tolerated will give you a little string, but not too much. So no, it was a more generous tolerance than that. The reason I'm struggling with answering your question, but I want to be forthright about it, is at the federal level, which is rightly where you're talking about, they saw that the federal republic would have almost nothing to do with religion, that religion would be done almost entirely at the state level, which is what my book is about. So they thought religion was divisive, which it was. It was pluralistic, because several different kinds of religions, although almost exclusively Protestant. But nonetheless, disagreeing Protestants. And so at the federal level, they understood religion was divisive. So let's keep it at the local state level. And they viewed it as a state law matter. It was simply not a the federal matters were fairly limited. You know, international relations, military to be sure, interstate commerce, commerce between the states, but most issues were state or local. And religion was one of them. That's why there were several established churches long after the Federal Republic was created, which shows the federal government was fine. You could have what we would view now as terrible oppression, a state church.
Right.
They were okay with that because the federal government was limited.
Got it. Thank you. Just so you know that if you have to leave, that's fine. I always hold a hard line within 5 minutes, so we will conclude at 1:20, but I think that we can just sort of let whoever needs to go. We'll stop the recording, but then you can stick around for a little while for
Sure.
conversation.
Yeah,
we can
absolutely.
wrap up. So another comment, question?
I got two quick questions, kind of related. What happens today? What's happening on the third flagpole in Boston? Did they change their whole rulings, their procedures? What's happening there? And related to that, other than winning the cases at a Supreme Court level, those who were litigants or whatever you call them, are they awarded any other remedy? In case of a football coach who loses a job, how was that sorted out and who sorts that out?
Yeah. All right. So first question is, City of Boston has suspended as they're studying their policy. So at this point, nobody gets to fly their flag.
That's what I thought.
And while even though things were suspended, one group came along and filed a request. And I'm not going to remember what it was, but it's a highly controversial, I don't know, American Atheists or something that was inflammatory or something. Something that they wouldn't, the good citizens of Boston would not have wanted that flag on their comments. So we don't know. And I should add, government can always close a forum. So, yes, there is a remedy, and it's a pretty good one. Congress, back in 1988, said that if the government is violating your constitutional rights and you sue the government and win, you get your attorney's fees. So I don't know what the attorney's fees will be like in the Boston case. But it probably will be, say, $800,000 in that neighborhood, because it went through, a couple of court systems and then to the Supreme Court. So $800,000, and even if it ends at the federal district court level, which is the trial court level, $250,000 expenses would not be unusual. You didn't ask this, but let me hasten to add a bunch, 5, 6, 7 groups Christian groups have formed of lawyers who take charitable gifts to them to pay for their organization. And then those lawyers volunteer to work for free. So even if you lose your case, you're not going to have to pay a lawyer. But if they win their case, then they get that money that otherwise would have gone to you to reimburse you for your attorney's fees.
Gotcha.
What about the coach?
About what?
The coach.
Let me interrupt real quick just to keep my word and thank everybody. Again, Carl, thank you for all you've done and continue to do for religious freedom. We're really grateful. Appreciate that. So I'll leave everybody online, but please, if you need to slip out, feel free to do that. But we're going to kind of continue the conversation here for a bit. I'm